All right. Well, welcome everybody. Thank you for joining us today. My name is Beth Boucher. My pronouns are she, her, hers. I am the internship supervisor for the Whitburn Center and the graduate assistant for the MPA program, as well as a candidate, hopefully soon to be graduating. I just again want to thank you for joining us this afternoon. So just a little bit about the Whitburn Center. It was established in the fall of 2021 through a generous donation from our founding benefactor, UW alumni Jerry Whitburn. Our mission is to conduct nonpartisan, practical, applied research focused on evaluating and improving governance, professional management, and public policy in Wisconsin and beyond. Our vision is to build local government, nonprofit, and community capacity to promote the common good. To do this work, it requires bringing people together in spaces like this to work together to share knowledge and equip public professionals with tools and resources to better understand the dynamic topic areas surrounding Wisconsin's public sector. We're happy to have you all join us and learn alongside you. And with that, on to today's topic. So today we are taking a deep dive into Wisconsin's open records and meeting laws with insight from former Vice-Chancellor for Legal Affairs at the University of Wisconsin-Madison, Ray Taffora. Attendees can expect to gain a practical understanding of how to navigate Wisconsin open records and meetings law with pertinent application for those working in or with the Wisconsin public sector. Raymond P. Taffora retired from a 35-year active law practice in August of 2021. Most recently, Mr. Taffora, I'm gonna mess that up every time, served as Vice Chancellor for Legal Affairs at the University of Wisconsin-Madison for 8 years, where he supervised the university's Office of Legal Affairs and the Office of Compliance. Prior to his work for the university, Ray served as the Deputy Attorney General in the Wisconsin Department of Justice, Chief Legal Counsel to the Governor of Wisconsin from 87 to 91, and as an attorney in the private practice of law for nearly 20 years. Ray earned his Bachelor of Science degree from the University of Wisconsin-Madison in 1983 and his law degree from the University of Wisconsin Law in 1986. So with that, we will move on to Ray's presentation.
All right, thank you, Beth. My apologies to the participants here. As I told Michael some time ago, I'm a real dinosaur when it comes to most technology, so I'm having others operate this, so I hope it goes smoothly. Happy to be with you today. Yes, let's take a sort of I'm not sure how deep of a dive we can do in an hour's time, but both the open meetings and public records laws, which are really important laws and sets of guidelines for those operating in the public sector, as most of you probably realize. When we get to the question period, in addition to these laws, I'm also happy to let people know how I got on the Whitburn Center board, my interactions over the many years with Jerry Whitburn, et cetera. So we'll save that for question time if you're interested. A disclaimer, I have to do this because although I'm a lawyer, I'm not your lawyer. And so as you might expect, this presentation is intended for your general information. We don't establish an attorney-client relationship here. And if you want specific advice, you really have to go to the Office of General Counsel at UW System, which has a fine group of lawyers. All right, let's start with the open meetings law. This law applies to UW bodies, most public sector entities known as governmental bodies, and it requires those governmental bodies to publicly hold meetings at places reasonably accessible to the public. Next slide, Mike. All right, so the term governmental bodies are defined by statute to include all groups created by statute, rule, or order Now, interestingly, both the Attorney General and recently the Wisconsin Supreme Court have held that order is not just an executive order issued by the governor, but virtually any directive from an executive or administrative official, which makes this, the application of these laws quite broad. As I indicate, broad enough to include almost any collective university entity. But as a practical matter, it mostly will affect those governance bodies or others that take formal action or working groups developing high-level policy. So for instance, your faculty, academic staff, university staff governance groups are going to be bound by this, academic departments when they meet as a whole, college or divisional committees, formally created units of any of these, like subcommittees of these groups, or if you have special committees, even advisory committees that are created by a chancellor, vice chancellor, dean, or department chair are also likely covered groups. So if you're a covered group, when does the open meetings law apply? Well, two circumstances. One, you're engaging in some sort of business. That is, you're not getting together for a party or some non-university business, and you have a quorum, that is a majority of those who can take action. Or in instances where certain things might require 2/3 or a larger supermajority to enact some particular policy, if you have more than enough to block a particular action. So there's a 2/3 requirement, and you have more than a third, for instance, present at some kind of committee meeting, the law would apply. And as I indicated, if you're getting together for socializing and no business is anticipated, then the open meetings law does not apply. When meeting, these covered groups have to follow the public notice requirements, which basically is giving persons notice of when the meeting will happen, where it will happen, and posting the agendas or other information about what's going to occur at the meeting. Usually those requirements are at least 24 hours in advance for most entities. So you follow sort of a 24-hour rule at the least amount. There's also a particular statute that says that the academic departments and their subunits are exempt from those specific requirements, except that they have to provide meeting notice reasonably likely to apprise interested persons of what might happen at the meeting and news media who have filed requests. A lot of times this is done by either posting in an area under the old-fashioned way of doing things, posting an area where you usually post notices, or online somewhere where most meeting notices are posted. So ballots, votes, and records. Generally, the open meetings law precludes secret ballots. That is, as a general fund, when you're going to take action, you take it in public. The election of officers of a body can be conducted by secret ballot. Otherwise, votes should be and motions should be recorded, preserved, and available for public inspection. When a roll call is requested by a member or it's required by law, then also that should occur. If there is no roll call votes, then the vote should be preserved by some other method, such as noting the names of those who voted for and against a measure, noting a voice vote, show of hands, etc. However, other than recording and preserving motions of votes, the law doesn't further require that covered groups keep minutes. Many do, but you're not required to do so in most instances. However, as many of you know, most governance groups in the academic departments do keep minutes and have long kept minutes, but it is a vulnerability from the open meetings law perspective. That is, those things will generally be accessible under the records law, which I'll talk about in a few minutes. Okay, the law does allow covered groups to convene in closed session. So there's a default rule that you're in open session, except if you're authorized. Well, when are you authorized? Well, here are a couple of examples. One, when you're considering someone's employment, evaluation, promotion, or compensation, so employment-related matters. When you're considering the financial, medical, or personal histories of persons where there might be a detrimental effect on reputation if there's a public discussion of it. Or another example is negotiating purchases, investments, or other business where there's a competitive or bargaining reason that would require you to go into closed session. That is, there may be other persons other than the public entity that wants to bid on a property or something, and you wouldn't want to telegraph to your competitors what's happening. Evidentiary meetings, such as peer review of disciplinary action, must be held in open session if the affected faculty or academic staff member requests. Okay, so if a closed session is anticipated, both the subject and the statutory exception citation should appear, or it must appear in the meeting notice. So when you enter into a closed session, you do so by the typical parliamentary way, which is a motion duly made and carried by a majority vote in a manner such that the vote of each member is ascertained and recorded in the minutes. That's required by statute. Okay. When the motion to convene in closed session is taken, it should be announced by the chair, who states the nature of the business to be conducted and the specific statutory exemption under which the session is authorized. That's the easiest way to ascertain and record each member's vote, and to do so by roll call. As to evidentiary sessions related to employee discipline, such as a faculty termination or a faculty discipline, they must be held in open session if the employee requests, but deliberations may be held in closed session under the law. There's some special rule for tenure meetings. So under the law, closed session may be held when considering the grant and denial of tenure for a university faculty member, but the tenure candidate must be notified so that that member has the right to demand that the evidentiary hearing or meeting be held in open session. Okay. However, the UW system has long counseled that the entire tenure consideration session, including the decisions or the deliberations and the vote, should be held in open session if the tenure candidate requests it. Okay, I'm going to suggest that we get through the public records law first before entertaining any questions, because the two are pretty interrelated. So let's go on. So that's the open meetings law. Let's go on to the public records law. So in its most general terms, the public records law provides that any requester may inspect and or copy a record that is not specifically exempted by some provision of state or federal law. So what's a record? Well, how's this for a definition? Any material on which written, drawn, printed, spoken, visual, or electromagnetic information or electronically generated or stored data is recorded or preserved regardless of physical form or characteristics that has been created or is being kept by an authority. Very broad. An authority is a state or local office, an elected official, an agency, board, commission, committee, council, department, or public body created by the Constitution or by any law, ordinance, rule, or order. Again, that term order comes into play here, and it's been interpreted by the Attorney General and the Supreme Court to include directives from executive or administrative officials beyond the governor. Importantly, record includes handwritten, typed, or printed pages, maps, charts, photographs, films, recordings, tapes, optical discs. So the definition of a record is very, very broad. A rule of thumb is if you're writing something down or recording something or typing something, and you're doing so pursuant to your official university capacities, and on university business, for university business, you've got yourself a record. Now, importantly, it does not include drafts, notes, and like materials prepared for the originator's personal use or prepared by the originator in the name of a person for whom the originator is working. Materials that are your personal property and have no relation to the office. Materials there where there's a limitation by copyright or patent, or published materials in the possession of the authority, except if you're working for a public library or they're for sale or inspection of a public library. The drafts exclusion under this particular provision is an important one because it allows you to record for yourself your own impressions of a meeting, provided you A, do not circulate those notes or drafts to anyone beyond yourself. And two, they're not used to memorialize sort of department or agency activity. So if you have your notes, you're circulating them widely, and you put personal notes on them, that the characterization of those notes is not determinative. Okay. If you're preparing a draft, you can shield that until there's a final version of a particular document you're working on. But the fact that you stamp a draft is, again, not determinative as to whether or not it will be a record in the last analysis. Importantly, this law is construed, as you see there, in every instance with a presumption of complete public access consistent with the conduct of business. The denial of public access is generally contrary to the public interest, and only in an exceptional case may access be denied. So the legislature has spoken rather definitively about the fact that if you have yourself a record, you're going to have a presumption that it's going to be subject to inspection and disclosure. The law requires that every entity, that is each office that has records, post a notice that describes the method whereby the public can obtain information, that is the records, and how you get access to the records. All right, requesters and requests. A request can be made by any individual, except a person who's incarcerated or committed to a mental health facility. Okay. Identities and motives of the requester are irrelevant. So you cannot quiz someone as to, well, why do you think you need this record? They don't have to tell you. And a request can't be denied because the person making it is unwilling to be identified or state the purpose of the request. Requests for records can be oral or written. There's no specific language, and you need not, the custodian of the records can't require the use of a particular form or term. Importantly, oral requests can't be enforced, only written ones can. The law also requires that a request has to reasonably describe the record of the information requested. And as one who used to supervise these functions at UW-Madison, I can tell you that the custodians often go back and forth with requesters because requesters frequently don't know what they're looking for. And so the initial volleys back and forth are an attempt to try to clarify what it is that the requester is looking for. And a request isn't generally sufficient if it's not reasonably limited as to the subject matter or period of time. So we get these requests at UW-Madison from time to time. We're interested in knowing what the chancellor's office was doing in the period from 1957 to 1977. Well, that's unlikely to be a reasonably limited time period. And so we would deny those requests or go back and say, well, what are you looking for and what years in particular? There are a number of exemptions. I've listed them here. I'll go through some of them. The types of personal information like home addresses, email addresses, social security numbers, or bank information. Information regarding or relating to current investigations of criminal or employee-related misconduct. Information regarding the employees of the university contractor. What are called staff management planning type documents, which are performance evaluations, recommendations for salary adjustments, etc. Very importantly, from attorney's perspective, attorney work product and attorney-client communications. Any investigative information that could prejudice ongoing investigations or the identities of law enforcement informants. Usually not the case at universities, but sometimes trade secrets. Identities of applicants for public officials, if the applicants indicated in writing a desire for confidentiality, or if the applicant is a finalist. So finalists are generally disclosable. Plans or specifications for state-owned buildings or state-leased buildings. You often wonder, well, why would a person want to know this unless they were going to do some harm? Computer programs, as I've mentioned. FERPA-related records, that's student records covered by FERPA. Medical records and physician-patient communications, and letters of reference or ratings related to employees, all generally exempt. The balancing test. In addition to specific exemptions, many of which I just listed, the law also permits a custodian to use what's called a balancing test to deny requests for records containing particularly sensitive information. So the idea here is based upon all of the facts and circumstances. Do public policy interests favoring non-disclosure outweigh the strong policy interests favoring disclosure? And if so, the records custodian has to say why that's the case and tell the requester and can withhold the record. A response. So the standard is, quote, as soon as is practicable and without delay, which is pretty prompt. This varies. However, the requests all should be taken seriously. Arbitrary and capricious delays could expose the custodian to punitive damages and forfeitures up to $1,000. The Attorney General advises that as soon as is practicable and without delay means you should have some sort of communication with the requester within 10 days after receipt of the request. Now, sometimes if a request is very voluminous but reasonable, you're going to have a communication that says, we have your request, we're working on it. If you have any questions, call us. But some kind of contact should be made with the requester in a 10-day period. Certain records subjects can challenge disclosure before it's made. Okay. Those are the records that are involved here are these three. One, a record that has information about an employee that's a result of an investigation into a disciplinary matter or an employment-related violation. Records obtained by subpoenas or search warrants, or records prepared by an employer other than the university, if that record has information relating to an employee of that employer unless authorized by the employee. So when you make a determination that a request is received, this kind of information is involved. The subject of the records has an opportunity to object, so you have to give notice. The person can reject or can object. They can seek a court order barring the release. However, if you don't do that within a certain period of time, the timeframes are not important for these purposes. You can release the records. So when you have these kind of records, you give notice. You have to wait. You can then release unless the person gives notice that they're going to seek a court order to block the release of this type of information about them. In terms of denying requests, if the request is made orally, it can be denied orally unless you get a demand for a written statement. A written request requires a written denial if any part of the request is denied. In terms of the reasons for denial, they must be stated specifically and sufficiently. You don't just deny requests by saying, well, under 19851C, we're not going to give you the records. You should indicate what the records are and why you think those records should not be released. You can cite a particular statute, but you need to explain why. Also, you have to notify the requester that the determination made by the custodian to deny all or part of a record is reviewable by mandamus. That's just an order from a court compelling a person to turn over something under the statute or upon application to the Attorney General or a district attorney in the county where the request is being made. In terms of providing the requested records, the office that has the records has to provide the requesters with facilities comparable to those used by the employees, but need not purchase additional equipment or provide a separate room for persons that may want to inspect or copy records. Often this isn't the case. People will request it, and rather than inspect them, they just want the records mailed to them. Okay. As I mentioned earlier, if the records in question contain information not subject to disclosure with information that's subject to disclosure, you have to provide the information that is subject to disclosure and withhold the information that is not subject to disclosure. The requesters are entitled to copies, including copies such as copies of audio and video tapes. You can charge for that, but the copying fees are limited to the actual necessary and direct cost of reproduction. The rule of thumb that is used, I think the AG might have advised on this as well, is about 25 cents a page. You can't charge persons for the labor involved in copying or redacting the records. So if you've got information that has some public information, some not, that's your responsibility. If there's an extensive search that's required, You can charge a locating fee, but only if the actual cost of locating the record is $50 or more. You can also charge the actual necessary direct cost of mailing or shipping the records. You can also require prepayment of a fee if the amount of the fee is going to exceed $5. All right, that's a lot to get through, and we've done it in pretty rapid time. So I'll now open it up for questions. And as I mentioned, there could be questions about these laws. There could be questions about Whitburn. There could be questions about my past career, whatever you'd like to ask, within reason, of course. I'll reserve the right to decline to answer some questions, perhaps. But any questions?
I'm guessing we'll have a lot. So if people want to just, either raise their hand or just chime in. There is one in the chat here, and I guess we can get started with that one, assuming I can figure out how to pull it up. So Gina asked, if you deny a request, does the requester have to re-request it?
If a request is denied, okay, there isn't specific information about how long you have to wait in order to request the information again. Usually the rule of thumb is if you've requested it in a reasonable period of time and you want to re-request, the expiration of at least some period of time, a year, 2 years or so forth, is the usual rule of thumb. Importantly and related to it, there's no such thing as an ongoing request. So sometimes you'll get requests that I'd like all of Michael Ford's scheduling information for this year and the next 5 years. So just periodically supply those to me. Those would routinely be denied. So you request in current time or in the past. And if you want more, you have to request again.
Other questions?
Great
Go
job. Thank you. I have a question here. You might have glossed or glanced at it about a little bit, but when it comes to personal devices, what about communicating on a personal device? Let's just say text messages, emails.
Yep.
When does a personal device become subject to open records if it's used for work purposes, and to what extent?
Thanks, Ben. Excellent question. A couple of comments. One, the public records law was drafted and enacted in a period before the onset of the vast explosion of modern technology. But the Attorney General has counseled the following, that what matters is the subject of the record rather than the medium that's being used. So for instance, if I am communicating with Michael on a matter involving, if I'm a university employee, I'm communicating with Michael on my cell phone by text. It's university business. It's subject to the public records law. Okay. If it's Michael and I talking about something that is incidental to university business, but not really university business, what are called transient records. That is, Michael, how about if we meet for lunch at 11:45 today? That's generally not a public record. But if you're using, but emails, personal texts, other sort of devices that are used to conduct university business where you otherwise would have a record that meets the definition, are subject to disclosure. Now, there are lots of practical challenges, aren't there, associated with these things, because it's not as though the university hands out all sorts of university telephones. Much of this is conducted by your own personal devices. Often what I would advise, or what has been advised by the system and the Attorney General, is when you're conducting university business, try to do it on university devices. If you have to use something that's quick, an iPad, it's your own, a text message, your own personal phone, keep those particular records in a place, or transfer them to university devices as best you can and as soon as you can, because they may be subject to the records law at some point and upon a proper request.
Other questions. So Jennifer asked if there is any cap for costs for an open record request. Is consideration given to requesters to receive the records electronically to minimize those costs?
Yes, good questions. There's no specific cap in the law. We always used a rule of reason and took into consideration, and by the way, the law does authorize a custodian to waive fees. So once in a while, what would happen is if you had a bona fide request from a particular requester, where there might be an issue about ability to pay, the requester and the custodian can waive the fees. Now, part of the problem with that is once you waive for one, then you have to decide, okay, what's the circumstance that allow you to do that? Would it apply to other circumstances? But there's no specific cap. Often what is done, however, is there is interaction between the requester and the custodian when the custodian will tell the requester, by the way, just so that you know, there are loads of records and you're looking at something that's going to be in the several $100 range. And that's where the request for prepayment comes, because the requester may say, I don't want them then. There is an opportunity also to get electronic records, and that's done relatively routinely as well. So those options are available.
Beth, do you want to explain your question from the chat? She had asked about destroying the records. I want to make sure that, I assume you don't want to destroy those records.
No, I was kind of piggybacking on Benjamin's question. So if you have these things that may be a record on your personal devices,
Yep.
but you want to clear your phone out, or you need to make room for other text, or you just don't want them on your device anymore, then what do you do with that information?
Yeah, good question. It's interesting. The preservation of records is generally not covered in the records law, somewhat surprisingly. The general rule of thumb is for general business records, and under the Public Records and Forms Board publishes schedules of the different types of records that there are and retention schedules for them. The rule of thumb I use is that if there's a genuine business record, I would default to a 6-month retention period. So if you're communicating and you think you've got university records, you should keep them for 6 months. There is a transient record rule, which is this, let's say you want, again, Michael and I want to go to lunch, but we're going to talk about university business. You don't really know. It's sort of some social and, some mixed, called a transient record. That is, it's not going to really be important after the occurrence of the actual date of the meeting. Then those are generally 3 days. I use a 3-day rule for those. Keep them for 3 days. But I would generally default to a 6-month rule. Sounds draconian, but better to be safe than sorry.
I don't know if it's helpful, Beth. I can tell you at least one of the things that that I do, both as a my university capacity, but as a local elected official, is if someone does communicate with me, at least via email, using a personal email or some other methodology, I always just try to copy the official email request on the reply to make sure that that record is preserved.
No, it's a good, and we in the legal offices would always tell people when we saw Gmail coming in from a professor or something, use university devices, because otherwise we get into this business about how long do you have to retain it. People are aghast when they find out that the use of their personal devices actually could result in public records if you're otherwise talking about university business. Again, it's the subject or the topic, not the medium that's used. I did see one in the chat there from, I think it was Doug. There are, beyond this information, which of course is the cream of the crop and the gold star, right, is my outline. But assuming you don't retain my outline, then the Attorney General actually has some fairly specific and exhaustive outlines that I think they're available at the DOJ website, both for the public records law and for the open meetings law. So I would direct you to those sites, and the statutes empower the Attorney General. They give the Attorney General the special power to interpret those particular laws. And so I would commend those particular, that particular information too. And I see somebody has, thanks Ben, has posted that in the chat, access to those outlines in the chat. And those are updated, I think, maybe every other year or so.
Awesome. And then Haley, I think it's Haley, has a question in the chat. In faculty tenure decision meetings, does the individual up for tenure need to be personally notified along with the general meeting notice? Does this apply only for tenure or other employment decisions as well?
Yes.
Okay.
Yes, I think that's, this law doesn't say that, but there are going to be other provisions of law that will require it. So the practical answer is yes.
I have a question. Maybe it's a little off topic, but I don't think so. One of the things that we run into, I find in local government a lot, is the walking quorum issue.
Oh,
I
yeah.
don't know if you can weigh in a little bit on that. I think it's
Yeah,
misunderstood a bit.
yeah, the walking quorum is a circumstance where I think it's the when you have the general rule is if you have a governmental body of, let's say, an odd number, right, 9 members, 5 would be considered a quorum to do a minimum of 5 to do business. What about breaking those numbers up into smaller subsets? Like, okay, you talk to 2 here and 3 there, another 1 here, and so forth. The practice is that's widely done. I would be cautious about it. In circumstances where you are, where it's going to be of necessity to do that, right? Okay, how do you, in order to ascertain, for instance, if you need to have certain, like the chairman and the vice chairman of the committee, what days are you available for the meeting, right? I think those are the sorts of things where you can talk about things for purposes of ascertaining individual schedules of the participants. But if you otherwise plan to talk about a topic that is within the authority of the governmental body, then I would be cautious about approaching individual members or subunits of the governmental body individually. Okay, I particularly in this instance where, and this happens once in a while, suppose that 3 of those members of the 9-member governmental body constitute the employment committee, and you inadvertently get together with 2 of them to talk about employment committee business, not realizing that you've got a majority of that committee. So you're not always, you have to be careful about what aggregation of members of a governmental body do you have such that you have a quorum to do business. So my advice was always to watch the walking quorum and what I call sort of the breakdown into individual units of members of a governmental body. Try to do as much of it as you can with the body in session as a whole, or convene the body if it's sensitive, potentially go into closed session if you can.
No, very, very helpful. Another question, this one coming from one of a couple municipal executives we have in the crowd here. Can you send memos to council or a report of information only that they are not making decisions on?
Say that again. I'm sorry. Can you send?
Do you want to say that again, Gina? I'm not sure what you're getting at there.
Sorry about that.
No.
I guess I was just asking the question of, can you send like a memo or an email with just information only, not necessarily information that they're going to be making a decision on, but hey, this is what happened in the city this week. Just want to make you aware.
Sure. Yeah, these laws don't restrict generally the flow of information. The only thing, Gene, I would suggest is that you want to watch that if you're supplying information at the last moment for, let's say, under the open meetings law, you get information at the last moment. Make sure if the governmental body is going to act on it, it's been a noticed subject, right? So that in the notice that you're not sending information, the chairman says, oh, by the way, we received this information, let's act on this memo, raising a concern, let's say, about broadening a particular street or whatever. It has, if it's not in the meeting notice, you've got a potential open meetings law violation. So that it's not the memo itself or the subject, it's just that if that goes to members of the governmental body, make sure that if they're going to act on something that's not noticed, that they don't think that this is your attempt to get them to do something and they trip up under the open meetings law because the matter hasn't been noticed and therefore can't be acted upon.
Thank you.
Yep.
Other questions? I guess, Ray, in your previous position, especially with the university and in the governor's office, like how overwhelming are the amount of requests that you receive? I'm just curious.
Yeah, it depends. It was the University of Wisconsin-Madison, like many campuses, it's a vast enterprise. And so at any particular point, first of all, there was a records custodian and 2 assistants, so it was a 3-person office. And I would say at any particular time, there were probably 3 dozen to 40 requests pending for information. Now, sometimes it can be as simple as, I'd like to have a copy of the chancellor's speech to the faculty senate last night. Other times it can be massive, like we had a request for all syllabi in a particular department in the School of Education. You know, which is something, okay, well, it's current, it's probably reasonably limited as to subject matter. There's a lot of it, but so you got to then, you know, get it from every individual professor, or what could be redacted, what can't be redacted. So it just depends. It's a lot. So the university had a lot. The Department of Justice, when I was deputy AG, had a lot. There was also a records custodian there and an assistant. The governor's office gets just a ton of them, as you might imagine. And the governor's office staff tends to be a little leaner. That is, they don't have as many employees as the Department of Justice or the university campuses generally, or at least UW-Madison. But at any particular time, Michael, I would say there were probably not fewer than a dozen or 15 requests pending, and up to sometimes 45 or 50. It can be quite a task. But it's a task the legislature says is part and parcel of, you know, governmental business, and you have to do it.
Yeah. Other questions? Do you see any downside, Ray, to these laws? And I'm thinking selfishly about,
Yeah, I mean,
back when I used to lobby, we used to
Yep.
never write anything down. It was just, it impacted our behavior.
well, it does. I mean, there depends upon the perspective, right? Probably not much from the public's perspective, because these are, you know, quintessential transparency laws. And I will tell you all, it's not a great secret, but I mean, judges in the public view these as almost holy writ. And so you have to be careful in trying to observe them, because the judges will be concerned if there's a proper action before them. Because the public likes them, the judiciary expects that you'll abide by them, et cetera. From the, you know, inside the government, from the university or the public sector, it's a major responsibility. But it's part of I think daily life in the agencies and in the universities. It does drive matters to oral conversation, right? Because then there are no records. And I would constantly tell people, why don't you lift the phone or walk down the hall and go see your colleague, rather than, particularly with the advent of new technology that, you know, Benjamin raised, for instance. It's so easy to tap a text out or write an email, right? But you're creating a record, and then you're burdening the records custodian with, you know, having to retrieve it, talk to you about it, disclose it. You know, if you don't like seeing your emails or your texts on potentially in the front pages of newspapers or online sites, then you best lift the phone or go see your colleagues if you can.
Yep, I'm laughing, Ray. I learned that lesson about 15 years ago, when all of a sudden some handwritten notes I had on a piece of legislation showed up in some investigative journalism. Said, "Uh-oh, this isn't good."
Yep. No, it's a burden, but it's a burden the legislature says you have to carry.
What, any other questions from the audience? I'm sorry, I can keep going. What are the biggest mistakes public employees make around open meetings and public records?
There's less exposure under meetings, because it tends to reach, it reaches groups of 2 or more, right? By definition. Once in a while, I think, you know, department chairs and so forth, when they're conducting some business, don't realize that they might actually have a meeting on their hands that at least they should talk to counsel about. So that's often overlooked. I think by far the lion's share, and I'm sorry, I'm talking about the university context. I know that there are some municipal executives here. This might be easier in the municipal context, right? Because you've got a common council, you've got committees of the common council, you might have special mayoral committees or commissions to which the law clearly applies. On the record side, it's what I just touched on. It's the, if you're going to write something down, be aware that this is presumptively a public record. If you want to take notes, keep your notes to yourself. You know, Michael Ford's notes or my notes or whatever, don't circulate them to anybody else. And you're probably going to earn, at least for purposes of the public records law, you're going to earn exclusion or exemption from disclosure. Now, of course, when there's a lawsuit, we know that this does not cover what we lawyers would describe as the sort of the civil procedure rules of legal action. So if you get a subpoena or request for documents under a proper case, they're going to have access to your notes. They won't get them under the records law, but they may get them by subpoena or otherwise. But I would just be thoughtful about writing things down. When you write things down, you know, don't get cute. I've seen some things like, you know, at the end of a memo, keep this, quote, keep this to yourself. If this gets out, it's curtains for all of us, close quote, actually written in a document. You sort of roll your eyes and you warn the person that there's about, you know, they're about to be embarrassed in a very public fashion if anybody who collects this record sees it and decides to put it on a website or publish it.
Very good advice there.
I would also, the other practical thing is I never write things down that suggest that you're trying to obfuscate the public's right to information. So, you know, also seen things like, you know, lawyers can do this because we advise people what their obligations are, what privileges they might have. But once in a while you'll see things like, well, let's, I'll meet you over there. We don't want to write anything down because this is too important to talk about publicly or something like that. It creates suspicion, and perhaps rightly so, that really is shouldn't be undertaken by the person conducting it.
Thank you. Joshua.
Hi, if someone makes a request at the university for something like email or official documents, I imagine the records custodian determines what's appropriate and what's not and goes through the materials.
They do.
But if that touches your own notes or your own cell phone, as we discussed, what party goes into your notes and determines what's relevant to the request or not, or goes into your text messages? Like who becomes in charge of that process?
Good question, Joshua. Yeah, typically the way this happens is it starts with a request to you, right? Because I mean, the custodian will not have your records. And there is some, I will say there is sensitivity, at least at UW-Madison, I think it's pretty widely followed elsewhere, about just calling up the IT people and saying, oh, by the way, let's tap into Joshua Garrison's email without him knowing about it and look through all of the emails he's been writing over the last 6 months. So it's a bit of an honor system. So the records custodian would talk to you, do you have notes, whatever. They would then go through that. In most instances, the good practices, and I think most follow it, there's a discussion with you. By the way, here's the corpus of the documents you, Joshua, has given to us. We think the following are not accessible. Okay, you probably would agree. We think the following are accessible. You may say, well, wait a minute, those are personal notes and so forth. And then the custodian will say, oh, I didn't realize that, because sometimes it's not evident. So there's usually a dialogue. I didn't get into this in depth because of time limitations, but there's really a rich dialogue that occurs within the public entity before these documents are sent out. And so we at the university would routinely have discussions where the custodians would be talking to professors. I mean, sometimes you get into, you know, material that's about to be peer reviewed, right? It's circulating around and so forth. And, you know, we concluded that's not accessible. And, but we might not know that if we hadn't talked to the person that was involved. And so it's a pretty good system, I think, particularly when you have a bit of a history and you have a professional record staff, that before anything goes out, it's reviewed by the person who has custody of the records. It's often reviewed often we did it at UW-Madison by, like, say, the press office, just to let them know, oh, by the way, or in some instances, the legislative office, we're going to release this. There's some information about Speaker Voss that's on these records. You should be aware of that. And so there's an attempt to try to get the university, all the elements of the university to know, or as many as you reasonably can. You know, again, consistent with the command that you've got to act as soon as is practicable and without delay, and otherwise talk to the requester about when you think you might reasonably get the documents to them. So thanks for that question. That's an important sort of inside the entity series of processes that's important to know. No, it's never that, oh, we get this request, give us what you got, we never talk to you and send them out the door. Not we, I'm not longer there, but the university wouldn't, or the municipality, I suspect.
Thank you.
Sure.
Other questions? I was struck by a comment you made, Ray, about the honor system.
Yeah.
Because that really, correct me if I'm wrong, but right, if I'm communicating with university business through my Gmail, and whoever I'm communicating with is also using their private email, it's really on one of us to release it if we're asked for it, correct?
It is. But, you know, much of the law and legal duty is premised upon voluntary compliance. This would be no different. But there is that element to be sure. What you don't want to have is something comes up and then it comes up later, or there's a suit over it and you get a subpoena, and then suddenly, aha, you find something where there's a bit more of a thorough examination, and then you could be, the university could be, or the municipality could be subjected to punitive damages for the arbitrary, capricious withholding of that information. That starts to stack up in terms of damages associated with that.
Oh yeah, I know I've seen cases where a requested record that wasn't given at the time shows up in a subsequent public records request because there was one person with a public email address involved, and it exposes the individual.
Let me also footnote, because I think back to Joshua Garrison's question about the interaction. What I described is obviously that which I knew about, which were both the way that was done at the Department of Justice when I was there, governor's office when I was there, and the University of Wisconsin-Madison when I was there. This is not required. I think it's a best practice. I think from recollection, I suspect that UW's system council strongly counsels the university entities to do the same thing. That is, obviously some interaction with the supplier of records so that you've got a good idea. But it would be, is it theoretically possible that you could be asked for records? You give the records to the custodian makes their own determination, never talks to you. Theoretically, yes, it's a pretty bad practice. And I don't think it's done that way very often. But it's something to be mindful of. And I think if any of you were ever, subjected to that, I'd let your university administration know, and they should talk to UW system council about, wait a minute, we've got to have a dialogue about these records because the custodian's not always going to know. And to speak up about it. Look, I'm giving you these records, but I think there are notes here and there's some sensitive material. Before you release them, I'd like to have a conversation. I suspect that'd be honored.
Makes sense.
Yeah.
Question in the chat here about attorney-client privilege, and I guess the question is, does attorney-client privilege always apply? So, I mean, I read that as saying as like records exchanged between an attorney and a client, are those subject?
Well, no, remember the attorney-client privilege is the solicitation of information, the supplying of that information for purposes of rendering legal advice. So sometimes lawyers are providing legal advice, then the privilege applies to both the providing legal advice and the information solicited that's necessary to provide the advice. But sometimes lawyers are giving mixed legal and administrative advice, right? So I could be advising you, Michael, about something regarding your duties and the fact that the records law provides the exemption for your personal notes. I could also say, oh, and by the way, with respect to the board meeting for the Whitburn Center next week, I really think we should discuss the following bits of information. That aspect of it is not covered by the attorney-client privilege. And you have to, again, you have to redact and partially supply that which is not within the ambit of the attorney-client privilege. Most of these evidentiary or other exemptions and privileges, by the way, as you could probably glean from the laws, are to be construed narrowly, fairly, but narrowly. That is, if there's a doubt about them, the presumption really is in favor of release. Okay, And again, because these are held in such high esteem by the judges eventually, you should assume that otherwise, because a judge is probably going to order release in an appropriate case.
Other questions? We have about 4 minutes, so speak now or hold your peace.
Well,
I guess anyway, just anything you want to sum up, Ray?
yeah, but let me just, I mentioned, I don't know how many of you would be interested sort of in how I came into contact with Gerald Whitburn, who's the benefactor here. It was when I was serving the governor's office as a young staff lawyer in the dates are not important, many years ago, it's in the mid 80s. And Jerry Whitburn was the Deputy Secretary of Administration at the time. So, which is a very important position. That's how I came to know him. And so I've known him probably since early 1987. So more than 35 years. He also gave me some of the best practical advice I ever had. When I was the governor's counsel, I thought I was quite the junior master of the universe. And I got into this habit of not returning phone calls very promptly because I was busy and I was the governor's counsel. Well, I got this call from Whitburn. I picked up and I said, Ray Taffora speaking. And he started off with the following quote: "Listen, Junior, if you want to get ahead in this business, you got to learn to return phone calls. I'm hearing you're not doing it. Stop it." Close quote. Well, it was stark advice, but boy, I keep telling him this all the time, which is why I'm sharing it with you. It was excellent advice because it was a bad habit at the onset of my career. I followed it, and I'm very grateful that he snapped that bad practice or wrung it out of me. But that's one of my favorite Jerry Whitburn stories, and he's been just quite a remarkable person. He's been the secretary of 2 different government departments in Wisconsin, the former Industry, Labor and Human Relations, and then Health and Social Services. And Health and Social Services is the equivalent in Massachusetts, in addition to being a corporate executive as the CEO of the Church Mutual Insurance Company. So and I think he was an aide to the Secretary of the Navy and then Senator Bob Caston at one point from Wisconsin. So he's really, you're lucky to have him as a benefactor, and he's the source of considerable wisdom.
Oh, I totally agree. And just the willingness to be able to share his networks, his knowledge, in addition to his financial resources to the benefit of this UWO community has been a game changer. And yeah, very well said, Ray. Well, 2 more minutes. Anybody else have anything they want to ask Mr. Raymond Taffora? If not, I can certainly say thank you to everybody for coming. I don't know if Beth, if you have anything you want to finish up here.
Yes, just thank you so much, Ray, for being here. It was such a great and informative presentation, and we just really appreciate you. And also thanks for everyone that attended. If you have any questions regarding anything, you can certainly email us at the Whitburn Center. Ray, if you'd like to if you have an email that you'd like to put in the chat for correspondence, that would be great as well. And then also we just invite you to tune in next month as we highlight some of the graduating capstone projects. So again, thank you everyone for coming today.
Nice to be with all of you. Thank you for your questions and your time.